So recently, Bombay High Court observed spouse suffering from epilepsy not ground for divorce under Hindu Marriage Act. It's not a mental disorder. So Bombay High Court observed that spouse suffering from epilepsy cannot be ground for divorce under Section 13, subsection 1, 3 of the Hindu Marriage Act. The Bombay High Court observed and upheld a family court order refusing divorce to a man. A division bench at Nagpur, comprising Justice Vinay, Joshi, and Valmiki, observed the condition of epilepsy is neither an incurable disease nor can it be considered a mental disorder or a psychopathic disorder for making a ground under Section 13, subsection 1, 3 of the Hindu Marriage Act. The court further said medical evidence does not support the husband's stand that epilepsy would be an impediment to the spouse living together. The bench relied on the 1976 landmark judgment of Raghunath Gopal Daftardar versus Sau Vijaya Raghunath Daftardar, wherein the Bombay High Court refused a man nullity of marriage on the ground that his wife did not disclose she suffered from epilepsy. Coming to the facts of the case, the petitioner husband approached the family court for divorce in 2013. His petition was dismissed in 2016, after which he approached the High Court. The wife plea for restitution of conjugal right was allowed. The husband filed the petition seeking divorce under Section 13, subsection 1 IA and under Section 13 subsection 1(3) of the Hindu Marriage Act 1955. He claimed that his wife had threatened him to commit suicide and her behavior was abnormal, leading to a breakdown in their marriage due to mental torture and cruelty. He said his wife was suffering from fits of epilepsy, which was an incurable disease leading to her being of unsound mind. He further claimed the mental disorder was of a kind that he could not be expected to live with. The wife denied allegations made by her husband. She claimed to have been driven out of the home and sought maintenance for herself and the daughter. She claimed she was under treatment of a neurologist since she lost consciousness twice, which was diagnosed as being a seizure, which was not an incurable mental disorder or disability which would incapacitate her. The husband examined the wife's doctor as his witness. Based on the deposition, the court noted that two facts were clear. First, that the women only suffered from a brain seizure and not from epilepsy, and the second, that epilepsy itself is a medical condition in which a person suffering from it can lead a normal life. Thus, clearly, even assuming the respondent was suffering from epilepsy, this was certainly not a mental disorder or a psychopathic disorder, or for that matter, can be even considered as leaving the respondent incurably of unsound mind. The court noted that it was after Raghunath Gopal Daftardar judgment that the provisions of Section 13 subsection 1(3) were amended with effect from 27th May 1976, allowing for claiming of decree of dissolution of marriage on ground of unsoundness of mind or mental disorder. It, however, applied the same judgment to deny divorce to the man refusing to interfere with the judgment of the family court. We hold that the petitioner has failed to prove that the respondent was suffering from epilepsy, or even that if she was suffering from such a condition, the same could be considered as a ground under Section 13 subsection 1(3) of the Act for claiming a decree of dissolution of marriage.